My name is Rob Eaton. I practiced law in Seattle. I worked at a big firm for about a year and a half, Foster Pepper and Scheffelman, and then I worked in-house at a company that had been a client of that firm, King County Medical. It later became Regents Blue Shield of Washington for about 5.5 years as Associate General Counsel. So when I was hired by King County Medical, when I was hired to be an in-house counsel, then I became an employee of that company rather than an associate or a member of a firm. When you're an in-house attorney, you're paid a salary and you don't generate revenue for the company. To the contrary, you save the company money, hopefully, by eliminating the need or reducing the need for them to send legal work to outside counsel whom they would pay a lot more money. So they pay you a salary, but you don't keep track of your hours anymore in a billable kind of way at most places where you work in-house. When I was an associate general counsel in-house, I answered lots of questions, as most in-house attorneys do. So when you're at a firm, as a litigator especially, you work on cases. The firm I worked at, we worked on medium to big-sized cases. So you'd have a number of cases going at any one time, but you were always focusing on cases. Whereas as an in-house attorney, I got lots of questions, lots of small questions. And there might be a few major projects that I was working on, and I might be overseeing the work of some outside counsel who were handling cases for us. But I dealt with a lot more questions before they got to the point of litigation. So potential litigation, customers who were upset, providers who might be a little concerned, or even reviewing new legislation, or other risks, and educating people within the company about how to behave in a way that would not result in lawsuits. My work generally in-house was more varied, resulted in the prevention, I hoped, of much more litigation, and occasionally in the overseeing of litigation, and occasionally handling some smaller cases myself. When I worked at Regents Blue Shield, we had just 2 attorneys, and the first attorney was general counsel, but also played a critical executive role at the company. So I ended up doing most of the day-to-day legal work for the company. As the company grew, we added another attorney, and eventually we became part of a bigger family of companies, and they merged their legal departments and now have, I think, more than 10 attorneys, and the attorneys specialized more than I did at the time. Often, in-house attorneys aren't equipped to handle big cases or major cases, and they instead farm those out to outside counsel. But they handle matters that might be on their way to litigation in hopes of preventing litigation. For example, I worked at a health insurer. If someone was upset that we hadn't paid a claim, I would deal with the correspondence with that person, and sometimes even initially with an attorney if they had one, in hopes that we could prevent litigation. But if it did get to litigation and it was a major case, then we would use outside counsel, and I would oversee them and work together with them in deciding on the strategy for the case. I can give you an example of the kind of matter that epitomizes for me what good in-house counsel do. I got a call one day from the attorney representing the Washington State Optometric Association. And I had never focused on the fact that there was a difference between optometrists and ophthalmologists. In fact, I'm quite sure I didn't even say the word ophthalmologist correctly until this case came along. But in the minds of optometrists, this is a big difference and an important difference. And they feel slighted. They feel like the neglected stepchild, if you will, in the realm of optical providers. And they were upset with some of our reimbursement policies and other policies in regards to optometrists. But this attorney was a very good attorney, because rather than rush toward litigation, he called me up and said, "Rob, my clients are upset. They'd love to sue, but you and I both know that's probably not the most effective way to get things resolved. Could we sit down and talk?" And I said, "John, I'd love to talk. Why don't you bring one of your docs with you? I'll bring my vice president of provider affairs, and I want to hear what you have to say. Let's see if we can find some common ground." They came, we talked. We listened, we heard. I talked with my client. I was part of the client. And we found some ways that we could change our practices that really didn't hurt us at all, that benefited the optometrists. We also found some areas where we couldn't change and explained why we couldn't change. And we went back and forth and eventually worked out an agreement that really wasn't a bad agreement at all for our company and that pleased the optometrists. entered into an agreement that made it binding and did it much more efficiently than if they had filed a lawsuit against us. To me, that epitomizes the opportunities that in-house counsel have. As disagreements are brewing, they can often work together proactively with those people who are unhappy with their clients' practices in ways that can resolve the practice differently than when you're simply dealing with the aftermath of actions that have already been taken as part of litigation. When I began, I was one of two, eventually one of three attorneys. So we handled some things in-house, but if it got to a case that was a bigger case, we then usually hired outside counsel. Initially, we'd used primarily a single firm, the firm that both my boss and I had come from. But over time, for certain kinds of cases, we would begin to shop around. We would invite several different firms to make a pitch to us. Frankly, they began to compete on price a little bit and come up with some innovative pricing arrangements. And we found sometimes that there were different firms that might help us better in different kinds of cases. We would then, I would then usually oversee the handling of the case. In some ways, almost like a partner at a firm oversees the case internally. I would help with some strategic vision for the case, review what they did, and authorize what they did. It's important, I think, for people who are working at a client and retaining outside counsel to understand that there are decisions that really should be their decisions and not just the lawyer's decisions. The lawyer should come and say, we can litigate this or we can research this in a variety of ways. How much risk would you like to take? For example, with a deposition, you can turn over every single stone, no matter how small, or you can cut to the chase and really go after the essential stuff. I found depositions I took when I was in-house counsel were much shorter than depositions I took when I was at the firm, where you worried about committing malpractice. But in-house, I was worried more about how much time it took or paying the bill than committing malpractice. And frankly, my own experience is that some firms were so averse to malpractice and had a culture of being overly thorough that they over-lawyered cases and really ended up charging more than needed to be charged. Not dishonestly, but they had simply very thoroughly researched the case or very thoroughly litigated the case. I found it's important for them to be upfront and for clients to be clear about just how much risk you are willing to take. And if you're willing to have a case litigated a bit more leanly or efficiently, to let them know that they didn't need the 10-hour deposition, a 5-hour deposition would do. So I would oversee cases with an eye to making sure that our interests were well protected, but also making sure that the firm really didn't do more work than needed to be done from our point of view for that particular case. I think it pays and is beneficial to both parties to create a longer standing relationship, recognizing there might be some kinds of pieces of work that as a client you decide to take to someone else. I think it's important that you articulate your needs and your philosophy well so that you have lawyers who represent you best in an overall way. For example, the company I worked for was a wonderfully ethical company. And there are times when we might have won a lawsuit, but I felt that we'd made a mistake and that we should pay, and the company simply paid. We cared about long-term relationships with our clients. That's a very different set of marching orders for an attorney than a set of orders that say simply, save us as much money as you possibly can. So it's important to decide as a company, what's your long-term plan? What are your most important priorities? And then to communicate those to attorneys so that you don't have attorneys who engage in scorched earth litigation that may help you win the battle but lose the public relations war for your company. I think it's important to develop personal relationships of trust so that you come to know that somebody has worked the hours that they've billed you. And usually you're working with a partner who oversees associates. You want partners who understand that you're not going to pay for meetings of 3 attorneys to philosophize about the case. And you want them to actually be the first ones to decide not to bill you for some inefficient work that a younger attorney did, instead of you as in-house counsel having to do that. When you find someone who will manage the work internally in their firm well, that's an important find. One great benefit to a company that gets big enough to have in-house counsel is that you can just walk by the attorney's office and ask her a question, which you really don't want to do when the meter's running. I mean, when you're paying somebody hundreds of dollars an hour, it has an enormously chilling effect. Unfortunately, because you might sometimes save yourself money with a 3-minute conversation with an attorney that prevents you then from doing something that later results in litigation that costs your company tens of thousands of dollars in attorney's fees alone. So I would freely take advantage of that, but also ask the in-house counsel, is this an appropriate kind of question? And they'll let you know often through their body language or explicitly what kinds of questions they're equipped to be able to answer. Sometimes people will listen to attorneys like they might listen to doctors and think that once one attorney has spoken, that is the law and that is what must be done. And attorneys tend to be risk averse and are trying to protect themselves and will often give inherently cautious legal advice. I probably shouldn't share this example because I saw it in a documentary years ago and may not quite have the details right. But the spirit of the story, I'm sure, is accurate. Years ago, IBM asked Bill Gates, a very young Bill Gates, for a couple of things, including a recommendation for an operating system. He referred them to a company in Monterey, California. So IBM sent representatives to this company and said, we'd like to look at your operating system. They were excited. They opened their briefcases and said, but first you need to sign this release. As releases of this nature often are, it was enormously one-sided in IBM's favor. They had an attorney review the release. The attorney said, don't sign, and you shouldn't let them look at it. This is a one-sided release. IBM said, you don't understand. If you don't sign the release, we won't do business with you. What should have happened is the attorney should have said, you know, there's risk. If this is an unethical company, they could look at your system, reverse engineer, steal your product, and you could lose everything you have. But there may be business reasons you want to do this anyway. That's your call. I'm just telling you this is a very one-sided release. That's what should have happened. But instead, the attorney said no. They listened and shut the door on IBM. IBM went back to Bill Gates and said, no go. What can you do for us? He went out on the streets of Seattle, bought DOS. And in the documentary, as I recall, they say the Monterey company's decision not to do business with IBM was the single biggest break in Bill Gates' multi-billion-dollar career. The moral of the story to me is that rarely should attorneys say, you may not do that. Only if it's illegal should attorneys say, you may not do that. Attorneys should say, there's significant legal risk or moderate legal risk or some legal risk as you do this. But there may be other considerations, ethical considerations, public policy considerations, public relations considerations that should also be taken into account. So as the business person, remember that you should usually retain ultimate responsibility for making decisions unless it's patently illegal for you to engage in certain kinds of conduct. Get great advice from attorneys, but balance that advice against advice that you get considering other factors of what the company does. And it's important for clients to remember that they need to maintain ultimate control over what happens in litigation and over what it is that the attorneys do for them.